Yeah, you can start.
Can I start?
Yes.
Good morning, everyone. Welcome to the Protection of Personal Information Act at the CIPC. Popia explained. My name is Shani Kelly, and I will be the facilitator for today's program. Advocate Lucinda Stienka will be our presenter today. She is the Senior Legal Advisor as well as the Deputy Director, Information Officer in the Corporate Legal Unit. The presentation will be as follows. The presentation will be followed with a question and answer session. During the webinar, you are welcome to post questions relating to today's topic under the comments. Loretta Klassen and Elsie Falani, also from the Corporate Legal Unit, will respond to these questions. Lucinda will verbally respond to questions after the presentation. If you have any questions that are not related to the topic, please log an inquiry on the CIPC webpage under Inquiry System or send a message on CIPC Facebook with Messenger. The recordings of today's webinar will be available on Facebook and YouTube should you wish to view them later. The purpose of today's presentation is as follows. Popia aims to give effect to the constitutional rights to privacy as set out in the Constitution of South Africa, Section 14, by introducing measures that will ensure that the personal information is processed by an organization in a fair, transparent, and secure manner. Okay, I'm going to do a brief introduction. As you can see, it's our program that we have in front of you. I'm going to give you a brief introduction on CIPC. Okay. CIPC was brought into existence by the Companies Act of 2008 in terms of Section 185, subsection 1 of the Companies Act. The Commission is established as a juristic person to function as an organ of state within the public administration, but as an institute outside the public service. CIPC is divided into two sections: the business, corporate regulations, and intellectual property. Corporate regulation is companies, cooperatives, and CCs, whereas intellectual properties is the innovation and creativity, patents, designs, trademarks, and copyrights. CIPC's objective. The objectives of CIPC is the registration of companies, cooperatives, and intellectual properties right, and the maintenance thereof, disclosure of information on its register, enforcement of the relevant legislations, promotion of education and awareness of companies and intellectual properties law, licensing of business rescue practitioners, monitoring, compliance with, and contravention of the financial reporting standards, and making recommendations thereto. Report, research, and advise the ministers on matters of national policies relating to company and intellectual property law. CIPC, as an innovative organization, has found creative ways to enable entrepreneurs to transact with CIPC. For example, registering companies online, as well as to educate clients through virtual webinars. CIPC embraced technology and what it has to offer to enable clients to submit their maintenance application and registration compliance requirements through usage of various platforms such as e-services, Bus Portal, and XBRL. CIPC has also developed a short course named Learn IBIS, which is free of charge to educate company directors regarding their duties and responsibilities. For more information on the course and how to enroll, please email me at elearning@cipc.co.za. CIPC, being a point of entry for businesses in South Africa, also complement other institutes of the DTIC, such as Triple B, Double E Commission, and Companies Tribunal in advancing the economy of the country. For instance, CIPC enables clients to obtain their Triple B Double E certificate through Bus Portal free of charge. Isn't that amazing? Now, I'm going to hand you over to Lucinda Stienta, who will continue with today's presentation. Just give her a few seconds to load her presentation. Yes, awesome. We can see your presentation. You can continue.
Thank you very much. Good morning, everybody. Just testing that I'm audible. If I can just get a thumbs up because I cannot see the screen specifically.
Yes, you are.
Okay, perfect. Thank you very much. Good morning once again. And thank you for that introduction, Shani. Today, I'm just going to take you through the Protection of Personal Information Act and how it relates to the CIPC functions. This is specifically related to exemptions in terms of Popia and how the CIPC tends to the requirements of protection of personal information. The Protection of Personal Information Act, we call Popia, falls within the ambit of the Department of Justice and Constitutional Development. And the purpose of Popia is essentially to ensure the protection of a person's personal information. That person includes a natural as well as a heuristic person, while still allowing for the effective access to information, which is embodied in PIA, the Promotion of Access to Information Act. Key in this context is to protect the personal information of persons processed by the public and private bodies, and to balance the right of access to such information and the right to privacy as set out in Section 14 of the Constitution. The information regulator has been appointed and together with a team of 5 members is responsible for the regulation of both PIA and Popia. Popia was promulgated on the 26th of November 2013 and came into effect on the 1st of July 2021. Definitions and purpose. In order to go through the application of Popia to the CIPC, it is necessary to highlight a few definitions. Personal information means information relating to an identifiable, living, natural person and, where it is applicable, an identifiable existing heuristic person, including but not limited to any identifying number, symbol, email address, physical address, telephone number, location information, online identifier, or other particular assignment to the person, the name of the person if it appears with other personal information relating to the person, or if the disclosure of the name itself would reveal information about that person. Processing means any operation or activity or any set of operations, whether or not by automatic means, concerning personal information, which includes the collection, receipt, recording, storage, updating or modification, the retrieval, alteration, consultation, or use of that information is defined as processing. Dissemination by means of transmission, distribution, or making available in any other form, or merging, linking, as well as restriction, degradation, erasure, or destruction of information. All of that falls under the definition of processing. It's clear from the above that any personal information that a public or private body receives is from the start deemed as the processing thereof, which has certain requirements attached. Even the destruction of information or making it available in another format than it was received is still deemed processing, and the Popia rules must be followed.
Lucinda, sorry about that for the interruption. Can you reload your presentation and let's see if it starts moving? Because
Is
we
it
are
not
still
moving?
No.
Okay, let's try that. Sorry for the interruption.
Okay, we will be presenting in a few seconds.
Okay,
I can see your presentation.
Okay, let's see if we can get it moving.
Okay, it's not moving, but you can continue, Lucinda.
Okay, well, don't worry too much about it. As I said, the presentation will be made available to everybody that is part of this webinar. So for now, you can just listen as I take you through the requirements. Public body. A public body means any department of state or administration in the national or provincial sphere of government, or any other functionary or institution when exercising a public power or performing a public function in terms of any legislation, which is very important. Public record means a record that is accessible in the public domain and which is in the possession of or under the control of a public body, whether or not it was created by that public body. The CIPC was established as a heuristic person to function as an organ of state. It's a public body in terms of the definition. Within the public administration, has a purpose of a public function, but as an institution outside of the public service. What is the point of POPI? POPI aims to give effect to the constitutional right to privacy as set out in the Constitution of South Africa by introducing measures that will ensure that personal information is processed by organizations in a fair, transparent, and secure manner. The purpose of POPI as it pertains to CIPC is to give effect to the constitutional right to privacy, as highlighted above, by safeguarding personal information when processed by a responsible party, meaning the CIPC, subject to justifiable limitations that are aimed at balancing the right to privacy against other rights, particularly the right of access to information, and protecting important interests, including the free flow of information within South Africa and across international borders. POPI must be interpreted in such a manner that it does not prevent any public or private body from exercising or performing its powers, duties, and functions in terms of the law, as far as such powers, duties, and functions relate to the processing of personal information, and such processing is in accordance with this Act or any other legislation. So what this basically means, and this is contained in the Act itself, is that the right to privacy needs to be balanced against the duty of a public body like the CIPC to perform its functions, like registration of new companies, intellectual property rights, etc. That balance needs to be there. As a public body, the Companies and Intellectual Property Commission must ensure that whilst it performs a public function in terms of the Companies Act, the personal information of its clients are protected and lawfully processed. Why the collection and retention of personal information? What is the purpose? To gather contact information of an identifiable, living, natural person and, where applicable, a heuristic person. To confirm and verify the identity of a natural person, ID numbers, or heuristic person, registration numbers, or to verify that a person or an authorized user of the CIP systems, processes, website, etc. For the detection and prevention of fraud, criminal activities, money laundering, or any other malpractice based in dishonesty, to ensure compliance with the Companies Act and other legislation that the Commission is mandated to govern, like the maintenance of corporate and IP registers, to conduct customer satisfaction, trend development, statistical purposes, and historical research, or to allow for such research activities to be conducted making use of the CIPC data. For audit and record-keeping purposes, the Companies and Intellectual Property Commission is the sole administrator and regulator of the Companies Act and other legislation as mentioned in Schedule 4 of this Act, and to provide the collected information in connection with legal proceedings and in the prevention, detection, and the prosecution of offences. Section 1874 of the Companies Act indicate that the Commission must establish and maintain a company's register and any other register contemplated in the Act, and make the information in those registers available to the public as efficiently and effectively as possible. So we have a duty to have these registers, to maintain these registers, and to make the information contained in these registers as effectively and efficiently available to the public as well as other organs of state, while still applying the principles of Popia. In order to look at lawful processing of information, we need to unpack the 8 conditions for lawful processing. These conditions are, in short, accountability, processing limitations, purpose specification, further processing limitations, information quality, openness, transparency, security safeguards, and data subject participation. I'm quickly going to go through each of these. Just in short, accountability in terms of the legislation means that the responsible party must ensure all conditions in terms of Popia are complied with. Organizational accountability, up to 10 years imprisonment or a 10 million rand fine can be attached to the CIPC if found not compliant by the information regulator. Processing limitation means that the lawful receipt of personal information and processing thereof in a reasonable manner. So process as little information as possible. Purpose specification. Information must be collected for a specific identifiable purpose, in this instance, a legislative requirement. Further processing of information must be compatible with the purpose of the initial collection. The information quality, the responsible party, namely CIPC, must take reasonable steps to ensure that personal information is accurate and updated where necessary and possible. Openness, documents must be maintained as referred to in sections 14 and 51 of the Promotion of Access to Information Act, PIA. The information regulator should provide clear guidelines on what information can be disclosed. Security safeguards. Security measures on integrity and confidentiality of personal information must be in place and maintained. The responsible party of each public and private body must take reasonable steps to prevent loss of information, damage, unlawful, unauthorized destruction, and unlawful access or disclosure. The above relates to both physical, your hard copy files, and cybersecurity, the automated services and systems. Data subject participation, the manner of access and exemptions must be taken into account, as well as the avenues of correcting or updating personal information. The conditions as described above are not applicable to the processing of personal information to the extent that such processing is excluded or exempted from one or more of the conditions in relation to such processing. Exclusions, you can have a look at those in terms of sections 6 and 7 of Popia. No part of the Protection of Personal Information Act is applicable to the processing of personal information by or on behalf of a public body when it involves matters of national security, such as the identification or financing of terrorist activities, defense, or public safety. Popia is not applicable in terms of the investigation and prosecution of offenders, such as the CIPC receiving subpoenas in terms of Section 205 of the Criminal Procedure Act. Such subpoenas require personal information of directors, members, and the entities themselves, like financial statements, and no detail may be withheld. These requirements are excluded completely from the Popia lawful processing requirements. Rights to access. Popia grants data subject the right of access to their information and the correction of that information. A person, which include juristic persons, has the right to know whether his or her personal data is being processed by a controller, the purpose for processing the categories of personal data being processed, and the recipients of that data. Therefore, every person, natural or heuristic, has the right to access their own personal information and to ensure that the information is correct, up to date, and accurate. In fact, the CIPC insists that personal information is reviewed and updated annually, which is made possible by filing annual returns. It is each data subject's responsibility to keep his or her personal information up to date and accurate. PIA grants the public and private body the rights of access to information. Exemptions, which is very important in terms of the CIPC's functions, you can find those in section 37 and 38 of POPI. Section 37 provides for the information regulator to grant exemption to a responsible party to process personal information if the information regulator is satisfied that exemption is in the public interest. This exemption specifically relates to the processing of personal information that is in the public interest and outweighs any interference with the privacy of the data subject. Section 38 provides for the exemption in respect of certain functions. Thus, personal information processed for the purpose of performing a relevant function is exempt to the extent to which the application of the provisions of POPI would likely prejudice the proper performance or discharge of the function. In other words, if Popia is applied completely and it interferes with the CIPC's legislative requirements to process personal information and to make it available to the public, that is where the exemptions come in. CIPC is exempted from certain provisions of POPI as it would not be able to fulfill its main objective in terms of the Companies Act and other applicable legislation if that does not happen. These specific exemptions include sections 11, 3, and 4, which relates to the fact that a data subject cannot object to processing. So there may be refusal of giving consent of processing of personal information, but that would just mean that you cannot transact with the CIPC. Section 12, personal information can be obtained directly from the data subject and third parties. In terms of Section 12, the exemption means that personal information can only be obtained from the data subject themselves. CIPC is exempted in this area, meaning that personal information can be obtained from the data subject as well as third parties. Section 15, further processing is allowed during the initial 8 conditions of lawful processing. We talked about the further processing of information other than the reason why it was collected in the first place. And the CIPC is exempted from this, meaning that we may process the personal information in terms of our registers in another way other than the reason for why it was collected, for example, disclosing that information. Section 18, notice to data subject when collecting personal information. Section 18 states that data subjects must be informed when collecting and processing personal information. The CIPC is exempted from this specific section, and data subjects are not informed individually when personal information is collected and processed. That is my story. I am very sorry that you couldn't see the slides, but as I said, we will provide same to you as soon as the webinar is finished. I'm sure all of your email addresses are here. If there are any questions in terms of Poppy, you are welcome to send it to popia@cipc.co.za. Thank you, Shani.
Okay, so once again, the email address is popia@cipc.co.za. Am I correct?
Correct.
I'm sure it's being shared um, on the chat, so you will be able to see the email address. Oh, I see there's a typo on the email address. Please resubmit it. Is there any questions that anyone would like us to discuss or elaborate? Is there any points regarding Popia anyone would like Lucinda to elaborate on? Y'all are welcome to put it on the chats so that we can have her elaborate on anything that you need to be explained. Wow, Lucinda, you did an amazing presentation. We have no comments or any questions. Well, it's almost 11, so I would like to thank you all for attending this webinar, this live streaming that we have. We hope that you found today's presentation informative and that it will assist you. Thank you so much for joining us. Please, if you have any comments, you are welcome to post it on our Facebook Messenger. We have a QRS system in place on our website, which all queries are attended to. I see I've got a thumbs up and a heart from Nelson, so I am very pleased that y'all enjoyed today's live streaming. Thank you once again, Lucinda Stienka. I am going to close this webinar now. Thank you. Bye.